appreciation for this work. So for today's talk, I have taken legal aid some reflections. I had the privilege to, in a few last minutes, by the learned speaker, suggesting how to enforce in spirit the issue of legal aid, which has largely remained in the fringe. Just to share a few examples, taking clues from him, I would say that I have seen in many institutions legal aid cells are indeed a type of formalities to fulfill the requirement of bar council or NAC. There are various compulsions why the institutions do it, probably because the students are not interested, probably because the teachers are also not interested, and both are not interested because it is not directly linked to the career. And I really appreciate the suggestion of the learned speaker that something should be done in this direction, and specialized teachers in this direction should be appointed. So I shall deal with 4 pointers: legal aid, why, the principles, where are the provisions, what are the reforms, and to conclude. Why legal aid is not a question to be asked. It is not a matter of bounty, not a matter of gift. It is a matter of right. The principle has already been enunciated by the Supreme Court in various cases. As a matter of provisions, there are expressed and implied provisions that we also know. I'm not going in those details of where are the provisions. Let us all understand that the legal aid is a matter of equality, it's a matter of equity, it's a matter of justice and level playing field. There abuses are always there. Some of us may be surprised how the legal aid is being abused. Just to cite one small example, not to suggest that use is not there, a lot of uses are there, but there are chances of abuse also. There are arguments in parliament attack case that the legal aid was not granted, and a lot of hue and cry has been made. But when we see the judgments of the Supreme Court in the parliament attack case, we find the Supreme Court has exclusively deal with the issue of legal aid, that the accused were granted legal aid to the extent possible. I shall come to the provisions under CPC and CRPC, and I have a special reason for it. Because CPC and CRPC are the provisions besides what is already there in enactments of NALSA and others. CPC, their provision, and the provision is Order 33, and I was going through it, discussing with my students also, and I was amazed to see that there is a provision for indigent person, and then indigent person is someone who has not possessed of sufficient means. This is all right. This not possessed of sufficient means is used in various places, but then Another provision or explanation suggests that if his property is of 1000 rupees, subject to one two exceptions, he is not entitled for that free legal aid. The last amendment that took place in 1976, to the best of my knowledge, 76 to 2023. Of course, we are aware and we are happy to know that the laws have been changed, the exclusive law has been made to deal with these issues. But the CPC is a provision which is known among lawyers, used generally in all courts. But the provision of 1000 is still there. Not high time that this provision should be amended. Therefore, I think that this provision should be amended up to 1 lakh rupees. That if he has a property worth 1 lakh rupees, more than 1 lakh rupees, then he may not be as per CPC, not as per other provisions. This I think need to be amended, need to be changed. Another provision that comes to my notice, section 304 of CRPC, deals with legal aid, but the provision is a very limited provision. The provision currently suggests legal aid only in court of sessions. Why only court of sessions? That comes to mind of everyone. I'm happy to see and share with you all that the 2023 Bharatiya Nagrik Suraksha Sanhita, the proposed CRPC, new CRPC proposed by the government, has noticed it to some extent, substituted the word court of sessions by court only. That is a positive development. When you substitute it by court only, all courts are duty bound to provide legal aid to the accused. But then there are two difficulties. It is more important to discuss because a parliamentary standing committee is discussing these all provisions. I hope these voices may go to the parliamentary standing committee also before they finalize. First difficulty is that clause 3 of 304, that still contains court of sessions. I think it is a miss either by the Criminal Law Reform Committee or by the ministry who has proposed the bill. Session word has to be removed from clause 3 of 304 CRPC. Second is that it gives discretion in the original CRPC itself. It gives discretion that for other courts provision can be made through High Court rules. I'm again surprised why this is still a matter of discretion. If the law is being amended, law is being changed, why cannot it be made a matter of duty of the state, of the courts, and a rights-based regime cannot be think of in the light of the fact that a lot of Supreme Court judgments are there. I think this is the second proposal that can be made, that a rights-based regime should be included and the discretion which is there with the High Court be made in such a fashion that it becomes a duty for everyone. I also find that the section clause 3 becomes redundant because when you use the word court in clause 1, it includes all the courts and there is no need of clause 3. Another point that comes to my mind is why CRPC talks about post-trial legal aid. Why not pre-trial legal aid? I'm convinced by the argument that there are other provisions that take note of, but then other provisions take note of this also. CRPC, as I suggested, is something which is a matter of everyday affair in the courts. Advocates, teachers like me and you talk more about CRPC and less about the enactment of NALSA and others. So even if there are provisions, I think CRPC should further be amended for the purpose of pre-trial legal aid. When I suggest pre-trial legal aid, I do mean to begin with FIR. Thousands of FIR are not registered every day. Lakh FIR registered every year, 50 lakh, more than 50 lakh are not registered. Justice becomes first casualty at the police station, which is the first protector of human rights. And court comes next. So at the level of FIR, accused and victim, there has to be some provision for legal aid. For the victim, what are the essential facts in his or her own words that has to be communicated? For the victim to suggest what should be the correct jurisdiction. Of course, zero FIR is already there, but what is the correct jurisdiction? Suggest the courts available in case the police does not register an FIR. At the level of investigation also. Before investigation, again in FIR, for the accused, is the accused entitled to the copy of FIR? There is no express provision that the moment FIR is registered, within 24 hours, within 48 hours, within 72 hours, he is entitled for that copy of FIR. There are some provisions when it matter goes to the court, some discretion is there to the police officers to give copy of FIR. Fortunately, there are Supreme Court judgments by High Court and by the Supreme Court also, which states that yes, an accused is entitled to the copy of FIR within 24 hours and he can apply for that. So the CRPC does not talk about anything, not the new proposed CRPC. I think a legal aid cell should also address this issue that you are entitled. My class and with many friends in many WhatsApp group, I have asked, is the accused entitled to the copy of FIR within maybe 24 hours, within 48 hours, within 72 hours? Suppose the police is suggesting that there is an FIR registered against you, you come to the police station. I am not aware of what is the content of FIR. Am I entitled? And most of them, some of them were lawyers also, said that no sir, there is no such provision, and that is correct, there is no such provision because people are not aware of Supreme Court judgments. So an amendment will make them more and more aware. So this will also address the problem of awareness. Investigation. When investigation starts, even it is a matter of theft, 3 years punishment is there. 498A, 3-year punishment is there. In many cases, having 7 year, less than 7 year punishment, पुलिस कॉल्स, पुलिस थाने पे आइए, आपके बारे में एफआईआर रजिस्टर है, आपसे आपका इन्वेस्टिगेशन चल रहा है. They are not aware that section 41A is also there. They are not aware means not the police, but the victims are not aware, the accused is not aware. So this legal aid to the victim, legal aid to the accused, that accused should be aware of, made aware of by the legal team of legal aid. Yes, you are not required to go to the police station because section 41 capital A of CRPC clearly states that notice has to be issued subject to exceptions. That Arnesh Kumar judgment also says the same thing. So this extortion business can also be stopped if legal aid is expressly included in CRPC, either in this provision or any provision somewhere. The provision of FIR for the purpose of FIR, for the purpose of investigation, legal aid should expressly be included in the new CRPC, proposed CRPC. Finally, if a news, if this FIR type provisions or in case of investigation type provisions, we need legal aid cell, then the question will come, where will this legal aid cell work? Because in the courts, there are legal aid cell, NALSA is there, SALSA is there, district legal service authorities are there, and advocates are also there. So if there are no advocate, the court can request any advocate to become an advocate under schemes of NALSA or SALSA. But how to enforce this suggestion that during, for the purpose of FIR also, for the purpose of investigation also, there should be legal aid cell. They cannot be there in the courts. My suggestion in that case is that it should be somewhere nearby locality of police station, preferably in the police station itself, a legal aid cell in the police station. I have tried to find that what are the implications of it. There are 18,000 police stations in India. 2022 report says there are 18,000 police stations. So police station, 18,000 police station needs some volunteers, say be some employee type thing, which are trained in this legal aid. They can be para legal volunteers also. There are students also who are aware of CRPC and other provisions, NALSA provisions, trained in that. So if every police station is required, I think 10 such volunteers would be required for every police station. Considering 8 hours, 3 volunteer, so it comes around 10 per police station. So it becomes 1,80,000 volunteers. 1,80,000 volunteers in every police station to deal with the issue of legal aid of FIR and investigation. Now it looks like huge. It becomes further huge when we suggest that such volunteers be paid 20,000 rupees per month. It becomes 360 crores per month. Multiplied by 12, it becomes 4,320 crores per year. So some of us, maybe I am also surprised with this analysis, because Ministry of Law and Justice had the budget 2023 union budget for 4,054 crore. And this analysis, my analysis says that 4,320 crore budget is only for police stations where the volunteers will be. Certainly, it is a huge budget, but then this is a matter of state list. The state should bear the uh, charges. It will come around 200 crore for every state. There are CSR fund that can be used for this purpose. If required, Section 135 of Companies Act can be amended. There are funds which are unutilized. Take example of Nirbhaya Fund. Nirbhaya Fund, a large amount of Nirbhaya Fund is unutilized. Can all Mahila Thana appoint all volunteers from this fund? I think yes. Can one third of the volunteer be only ladies and then appointed through Nirbhaya Fund? I think it can be done. There is no legal impediment. So funds are there in Nirbhaya Fund. So now you see the huge benefit. FIR is not timely registered. If volunteers are there, there will be additional pressure. FIR shall be timely registered. It shall be suggested that you don't implicate all people. Take example of 498A. The husband is torturing the wife. We generally implicate, it is suggested that they implicate father-in-law, mother-in-law, brother-in-law, all. These volunteers will suggest that no, that is not the right way. So long run, we will find that it is going to benefit the legal system, the criminal justice system in a huge way. But this is not a very big investment. So with that, I conclude this part of discussion. I suggest that there can be 6 ways to enforce this legal aid. First is the educative way, that we educate our students, that we are doing in our constitutional law classes, in clinical legal aid classes. Then second is the persuasive way, we persuade the students and the teachers and the advocates to do it, and some of us are doing. Then third is to incentivize it. Students are getting some points for it, teachers are getting some points for it. For example, can in API there can be a point if you have done something for legal aid. Of course, I understand that is not the ideal way, but there can be better ways which can be found. Incentivize it. There can be some coercive way. Coercive means that someone should be made responsible for legal aid. Like currently, the courts are responsible, the government officers, the government pleaders are responsible that that they have to see that the other party has sufficient legal aid counsel. If they are not doing, some action should be taken. And can there be some compulsive way, like through use of technology, that legal aid has to be given? If it has not been given, clearly mention that no, not it is not required. And finally, the punitive way, which I think is the last resort probably, that in case somebody is negligent, not taking care of this, some punishment, some measures can be there. So the 6 ways, the way we can, besides these all amendments that I have suggested. Thank you again, Professor Bhatt, for inviting me and giving me time. I again share my pleasure to be a part of this August gathering. Thank you again.
Thank you so much for your time and for your insights. And so, on legal aid and the reflections that you had, and the unique way in which you deal with topics, that's always